Hello,
Hello.
welcome. The appointed time has arrived. So we have um, many more people actually attending remotely. I think we had 40 or so that registered. So we've got in person and remote at the same time. So that's kind of cool, huh? All right. So we get to talk a lot about estate planning here, or introduction, I guess. Before we do, any questions about anything? As we have questions from those that are remote, they would text in a message, and then Will back here will speak for you if needed. And then if you have questions, I might repeat the question so that they can hear, so everyone can hear what the question is. So, all right. All right. So we're talking about the importance and the power of planning ahead, the estate planning, and why estate planning it really matters to everyone. And there are reasons for preparing for ultimately when we pass away, right? But it's also, there's a lot of estate planning that applies to you while you're living, for sure. And so you just want to understand there's reasons to do it for both. And we're going to go into that. So my name is Lane Martinsen, and I'm not an attorney, financial planner. And so today, don't take anything as legal advice or tax advice or investment advice. That's only done in a personal setting, right? So one of the advantages that I have had as a financial planner for, about 28 years now is that I've had the opportunity to see many people kind of go through the process, one of retiring, but also of passing away, some of our older clients. And so now you've probably had some experiences within your own family and with friends or neighbors. So I have, I guess, the unique perspective of being able to see that up close and personal with a lot of people over the years. And it's amazing just how if there's no planning, sometimes we get people come to us after someone's died and want us to help sort it out, and it's just there was no real planning, and it's very difficult. Things get hung up in legal, situations, and so I've seen it where it doesn't go well, and I've seen it where it goes very smoothly as well. So one of the key things with estate planning is avoiding probate. Okay, it's only one part of estate planning. It's certainly not the whole thing. But so let's talk about that. Okay, so let's say that we used to use an example of a husband and wife, and assuming that, when one spouse passes away, typically the assets are owned and controlled by the second spouse. But after the second spouse dies, let's say these are the beneficiaries, right? Maybe they're their kids, or whoever they are, they're heirs. Okay. And so if there was no estate planning done, and let's say at end of life, they have some money, they have some assets remaining, maybe some real estate, right? The house. Do the beneficiaries have access to those funds if there was no estate planning done? And the answer is no, right? The assets are technically frozen, and it's going to require a process. We kind of have this canyon that separates the two. The process, anyway, what's the word for that process? It's probate, right? And so probate is a public court process. And they're going to have to go through, before they get this, they've got to go through this process, and the judge is going to be the one who determines what happens to the assets. So there's a lot of downsides to going through probate, which we're going to point out here, and probate can be avoided very easily with some simple planning, some simple documents in place. So there's 8 basic steps to probate. The first thing that's going to need to happen is there's going to need to obtain a death certificate. There's going to be a determination if there's a will that exists or not. All of you everyone has an estate plan, and you all have a will. It's either yours or if you don't have one, the state has one for you. So it's not like there's nothing that exists. It exists, but it's not necessarily what you probably want or your family wants. So when you do estate planning, you're basically making your wishes known of what you want. It's going to require an appointment of an executor or a personal representative. The court is going to require that all interested parties are notified, creditors, family members, etc. Then they're going to require an inventory of assets. And this is where you could send your kids on if you're not organized, you can send them on a goose chase, a scavenger hunt, going through your dresser drawers, trying to figure out what accounts you may or may not have. And there's a lot of stories. It's amazing. There's actually a significant amount of assets that go unclaimed because the beneficiaries or the people who would have inherited those assets simply were not aware that the assets existed. And there's cases, there's just lots of cases like that. Even with life insurance, it's in the billions of dollars of life insurance death benefit that doesn't go to the right person because the person didn't know the policy existed. And so a big part of estate planning is just being organized and having everything all clearly documented in one place and greatly simplify it for your family, for your beneficiaries. After the inventory of assets has been completed and the court feels like they know everything that you had, they may be missing something, right? But as far as they have been able to determine, they know what your assets are. They'll require a payment of any claims that are outstanding to creditors, if there's any outstanding liens, any credit cards, unpaid balances. All of that has to be taken care of before anything can proceed beyond that. Then they're going to require a final tax return. It has to be completely done and submitted and filed before any of the assets are unfrozen. Okay, so as you can imagine, this can be a timely process, and it can take a good amount of time. And then eventually distribution of the assets. And again, if it's not according to your wishes, the state and the judge, based on the law, will make his best or her best judgment on that. How many of you remember Sonny Bono? Sonny, he was actually a politician, right? At the time, he was a member of Congress. But very unfortunate accident. In a skiing accident, he died in 1998. He did not have a will. He did not have any kind of estate planning in place. So his wife, Mary Bono, at the time, went down and became the estate's administrator and started working on the probate process. And then his ex-wife, Cher, came onto the scene with her attorneys and said, he owes me for child support and alimony that he did not pay. And so she was contesting and suing for 1.5 million of his estate. Okay. And then there's this 30-year-old man who comes along and he says, my mom and Sonny had a relationship 30 years ago, and I am his natural born son, and I think I should get some of his estate. And so, now how do we know all this? Because probate courts are very public. It's all public information. If you want to find out, you can do an internet search, and your neighbor can find out everything you got going on in your probate course. So, not ideal. And so here's kind of a little chart of what happens in a contested probate process because it really complicates things. Welcome. And so in the case of Sonny Bono, his estate, that probate process lasted almost 4 years. It's just shy of 4 years. And a ton of extra money was lost to attorney's fees. I'm sure it's the last thing Sonny wanted, right? Was having all of his private affairs out for the world to talk about. And so you can just imagine the person who's, his wife in this case, who had to wait almost 4 years before everything got freed up. Such a burden and so heavy. And yet very simple to bypass. It's really quite easy to just skip all of that with some estate planning documents, okay? So anything that passes via contract will completely bypass the probate process. So what's an example that comes to your mind of a contract that would bypass? Yes. A lease with the radio tower. It is a contract. If it's got, the contract would have to spell out who the successors are. Yeah. And so any other thoughts? What's another contract that would pass an asset that would avoid probate? Beneficiary. That's very good. A lot of people actually skip that one. But just a beneficiary designation on an account is a very high legal standing. And whoever is named as the beneficiary, that money is, whatever that is, it's theirs. It's very quick, it's very private, it's immediate. All they need to do is they get a copy of a death certificate and their ID, and they say, this is my account now. It's just, nobody knows about it, and it's done. There's some drawbacks to beneficiary, using beneficiaries, but in theory, if you name beneficiaries on all of your accounts, those accounts will bypass probate. Okay. Any other examples come to mind of a contract that would bypass probate? Okay. The first thing I usually hear in a class like this is someone will say a will. And so a will actually does not avoid probate. A will kind of guarantees probate. So to have a will is certainly better than not having a will, but a will just simply lets the judge of the probate court know what your wishes are. So rather than him or her trying to figure that out, at least your wishes are known, okay? But it can be contested. It's known. People can say, hey, no, I disagree with that. And there can be lawsuits, just like there was in the case of Sonny Bono. And so it's all very public. How many of you remember Aretha Franklin? She passed away in like 2018, I think it was. And at first, they thought that she had no estate planning done. But then in a safe, they found a handwritten will. And it left assets to specified people. But then in her couch cushion, in the sofa cushion, they found another handwritten will that she had written. And it left assets to different people. And so this became a very contested court case. It lasted for 5 years. She has 4 sons. 3 of them were suing each other. Expensive. I'm sure family relations are much, I'm sure they were damaged for sure in that process, where I'm sure Aretha would have preferred that her sons were not fighting over her assets, right? So again, it's really quite easy to prepare yourself and avoid any such thing. Now, in the case of a handwritten will, are those valid? well, they're not necessarily recommended, right? It depends on the state, and it's about half of the states will recognize a handwritten will, but each state has its own, criteria or conditions. Yeah.
Does it have to have a witness signature as well?
Yeah, it's going to vary by state. So some say the whole thing has to be written in the person's hand, has to be signed in their hand, and then some states will say it has to be witnessed, or others can just say, I think in the case of Aretha, I don't think there was any witnesses, but it came down to a Michigan jury, and they said, we think the handwritten will under the sofa cushion was her last wishes, because it was later than the one that was in the safe. Anyway, so that's what ultimately decided where her money went, was that handwritten will. So a will transfer assets, right? But it's going to go through the process. It's going to go through the probate process, beneficiary designations. But you can't necessarily put a beneficiary on everything, right? There's only certain types of accounts that you can actually designate a beneficiary. And then there's trusts, right? A revocable living trust, which we'll talk about. So my first homework assignment for you would be to just double check all of your beneficiary designations, just to make sure you've got them the way you want them. There are some, yes, Will.
One question from the chat. Yeah, will designating beneficiary of account bypass?
Oh, yes. Okay, so that's a good question. So what if you have a will and it says the money is left to these certain people in this certain way, but you have a beneficiary designated on an account? Which one wins? The beneficiary wins every time. So yeah, there's some, and it's the same with the trust too. So whether it's a will, whether it's a trust, if you've got a beneficiary designated on the account, that person that's identified is the new owner. It's just very cut and dry. It's a legal contract. And so there are some really some horror stories. For example, a guy starts his job at this company. He sets up his 401k. He gets married. He's married for 2 years. Ends up getting divorced. His wife is the beneficiary on his account. He remarries wife number 2. He's married to her for 25 years. He passes away. She comes to find out that his first wife is still the beneficiary. It never got updated. Guess who gets the money? First wife. Absolutely. So you got to be very careful for unintended consequences, right? Now, there are other types of accounts. So when you set up a retirement account, 401k, a work, an IRA, a Roth, anything like that, we're required when we set those up to establish beneficiaries on those accounts. It's part of the law. You have to set up beneficiaries. But that's not the case, and it doesn't apply to other types of accounts. So if you have a savings investment account, a brokerage account, if you have a savings account, a bank account, no one's asking you, do you want to designate a beneficiary on this account? Most of them don't have beneficiaries, right? But you can designate beneficiaries. And it's typically referred to, so if it's an investment account, they're referred to as a TOD. It's a transfer on death form. But you just have to either request it, or you just basically designate a beneficiary on the account. And if it's a bank account, savings account, they're usually referred to as POD, or payable on death forms. And you just designate beneficiaries. So any questions about any of that? Okay. Now, when you look at beneficiary forms, a lot of times you'll see these two words, per stirpes or per capita. And you might, if you don't know, they're Latin words. And so how do you make a decision? Should this beneficiary be per stirpes, or should they be per capita? And this what it does, it has to do with contingent beneficiaries. So if you have a primary beneficiary and then a secondary, that'd be the contingent. So that just means if something happens to this person, then this person is the beneficiary, right? So per stirpes or per capita has to do with if you predecease those beneficiaries and it doesn't get updated, or maybe so let's say, for example, let's say you have 3 kids and those are your beneficiaries. And let's say one of them's in an accident or something, okay, and they're not there. And maybe you were with them, right? So maybe you're both gone at the same time. So if you had a third, and a third, what happens to this person's third? That's what this is talking about. And if it was per capita, this person's third gets evenly split among the remaining 2. That's per capita. If per stirpes is, it would follow this person's bloodline. So if there's grandkids, it would go to them. Okay. So if you've got, it can become a little bit challenging to try and manage everything with just beneficiary designations, especially when you think of contingent and being able to control it. And that's where trusts will really shine and be more effective than a beneficiary. How about real estate? So how do we transfer real estate? In most states, it's going to vary state by state. In most states, the only way to avoid probate is having a trust. And that's the majority of states. There's a good number of states, I think it's around 15 or 16, that if you don't have a trust, you can just designate a beneficiary and it's a beneficiary deed. And so Arizona happens to be one. But when you do a beneficiary deed, you're still probably going to want an attorney to help you do it. And when you look at, and we'll talk about some of your estate planning options, if you don't have estate planning documents in place, I think it's better to just do a trust rather than beneficiary deed, but it is an option to do, okay? So a trust, when we talk about a trust, we're talking about a revocable living trust. So what does that mean? It means while you're living, it's revocable, meaning you can change anything because you're the originators, you're the trustees of the trust. It means you can put assets into the trust, you can put assets out of the trust, you have full control. But upon your death or death of the second spouse, it becomes irrevocable. So now the beneficiaries, so what you would typically have is you're the trustees and then you have successor trustees. The successor trustees or trustees would be, after you're gone, they become the trustee, but they're now the trustee of an irrevocable trust. So they're not like you where you could make changes, do whatever you want. They have to just follow the trust because you can't change it at that point. Okay, now a trust has to be funded. So if you have a trust and you never put any assets in it, or you didn't know how to use the trust, and you die, it has absolutely it just doesn't do anything. It doesn't control any assets. And so assets are out of the trust, goes to probate. The fact that you have a trust doesn't mean anything unless you use the trust, okay? And it's pretty common practice, like I've seen it over the years, where an estate planning firm, they'll do the trust and then they'll give some instructions. Okay, here's how you fund the trust. And then people go home and then do they actually do it? It's a huge percentage of people that they're not really sure what that meant. It's a little challenging, and then the trust has no real use. So there's 2 ways to use the trust, okay? You either retitle accounts into the name of the trust, and that's how you fund the trust. But some accounts you can't and don't want to retitle, such as like IRAs, 401ks. If you were to retitle those, that becomes a taxable event. So retirement accounts have special tax rules, and so it has to be tied to a person with an eventual death date, right? A trust does not have a death date. It'll live on forever. And so you have to know how to use that. So non-qualified accounts, like investment accounts, brokerage accounts, real estate, you would want to put into the trust. And then any retirement accounts that you have, you can use the trust as a beneficiary. So if you're married, in a married couple, from a tax standpoint, it's best to have the spouse as the 100% primary beneficiary of a retirement account, because when they inherit it, it's the best tax scenario you could have. There's no negatives to that from a tax standpoint. But then when the second spouse dies, then that contingent beneficiary could be the trust. And so even if a trust was completely empty, but you used the trust as the beneficiary on your accounts, at death, boom, 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 everything funds right into the trust to the beneficiary designations. So non-qualified accounts can already be in there. Qualified accounts would fund in after. So it's usually going to be a combination of how you use that. That makes sense to everybody? So trust is going to give you privacy. It's completely private. Nobody knows anything that's going on in the trust except for you. Your neighbors can't do an internet search to see what's going on like they could in a probate. So privacy is a big factor. Control. Hello, Paul. Welcome. So a beneficiary designation, you have no control. Like I said, it's immediate, and the asset belongs to that person. With a trust, you can control it in a lot of ways, and you have flexibility. It's kind of nice when when a trust is in place, and when you have multiple accounts, you've got maybe real estate, especially if you have multiple. If you have real estate and you've got some property in a different state or even a different county, perhaps, and you go through probate, now you just put and there was no estate planning, you just put your beneficiaries through two probate processes, right? Because they're in different municipalities. But you can have a trust that you can have multiple real estate holdings, which is going to greatly simplify that, and it's going to completely bypass probate. And then the flexibility to simply update the trust if something changes, rather than having to go to the different accounts and update each beneficiary. So I don't know if any of you remember this movie, The Ultimate Gift, but it was a movie, I don't know, it's probably been 20 years ago or 15 when it came out, but James Garner is this grandfatherly figure in this movie. And he's a mega wealthy guy. He's got like $2 billion. And so he creates this elaborate trust in the movie. And so his kids are also, they're super wealthy and they're super spoiled. And he doesn't really want any of his kids to actually get, the big $2 billion thing. But he has this one grandson that he has hope in and favors, but he's kind of a spoiled brat too. And so in his trust, he uses video. He makes video messages to be shown after his death, and so he talks to his grandson. And he basically says the trust is contingent upon the grandson developing true character. And so he builds in all these things, like he has to work on our cattle ranch, and he has to learn how to fix fences, and he has to, so he has to do all these things. He has to do them willingly, or he's dying. And he doesn't even necessarily know that he could get the whole thing if he kind of follows his grandpa's direction. Anyway, I think in the movie they refer to it as they'll refer to it as his last will and testament, but it's not. You can't do that with a will, right? The only way you can do that is with the trust. So if you're looking for a movie, you might want to check that one out. All right, so planning for incapacity is, so this is some of the state planning for when you're living, right? So it's for giving someone else the power to make some decisions on your behalf if you're unable, but you're still alive, right? How many of you remember Terry Shrivo? So Terry was in her 30s. She had a heart attack. She survived, but she had lost so much oxygen to her brain did not survive. And the doctor says she's completely gone. She is never coming out of this coma. But she was otherwise healthy. And she could be kept alive quite easily with a feeding tube. And so her husband at the time comes along and says, look, I know Terry, she wouldn't want to be kept alive artificially at great expense with no hope of ever coming out of this. So, let's end this. But then her parents felt differently. And they said, no, we want to keep her alive every possible moment. And so there's immediately this wedge between her husband and her parents. I'm pretty sure that's not what she wanted to happen. And that wedge just got bigger and bigger. And so, so you think of the expense, but anyway, so it eventually came down to a very dramatic appeals process where there was a court order that said, take out the feeding tube. It's on the news because it was such a big case. And then they took it out. And then there's immediately an appeal. The court says, no, put the feeding tube back in. And then eventually the appeals process failed and they took it out. She passed away in 2005. But she laid in that bed for 15 years. I mean, think about the expense of keeping someone on life support for 15 years. And it was just, so, I mean, that's a real extreme example, right? But you don't want anything like that to happen. And so whose decision should it have been? The husband's? The parents? If she had kids? No, it should have been hers. It's her decision. You don't want to leave this to anybody else. You don't want the burden to be on someone else. So that's called a living will. And it's a healthcare directive where you say, under these conditions, this is what I want. Now, she could have say, if I'm breathing, keep me alive no matter what. That could be her choice. But it would have been her decision, not family members that are fighting, right? Or she could say, if you've got two doctors, they both agree, I'm never going to see the light of day again, please let it go, or do not resuscitate. All those types of things are healthcare directives.
I mean, can't come on and say, no, I don't want you to die.
That's right. Yeah. Yeah. Now there's a difference between a living will and a healthcare directive where you say it's kind of life and death type stuff, those types of decisions. But then to have a medical power of attorney, which might be a spouse or a child or whatever, that gives them the authority to make some decisions, but it's not going to ever override the living will on a life and death situation. It might be like the doctor say, okay, we could do this procedure or we could do this one. Here's the pros and cons. Here are the pros and cons. We need someone to make a decision, but the person's not able to make a decision. That's where the medical power of attorney would make. So they can make a lot of decisions. It's just there's certain ones that the living will is going to be the final say on. Yeah. And so here's some of the core documents. Like I said, a living will, healthcare directives, power of attorney. So when you have a power of attorney, and everyone should have all of these documents. Everyone should have these documents. Doesn't matter. Sometimes people think estate planning is only for people who have a lot of money. No, everybody needs estate planning. There's there's a financial power of attorney that's going to allow someone to make some financial decisions. Let's say you're in some kind of a coma or whatever, and it would give someone that has the authority to make a mortgage payment or to pay a utility bill or just to help take care of your situation, your finances. Someone that could withdraw some money and make a payment, someone that you trust. So that would be a financial power of attorney. And then, of course, the medical power of attorney. You're usually, most of you are going to be dealing with the durable powers of attorney, which means they don't really kick in until you become incapacitated, and they endure your incapacity, and they continue on, and that's when they become effective. Now, a statutory power of attorney would be for a different purpose. So let's say you're going to take a trip to Europe for 3 months, and if there might be some important decisions that someone needs your signature on for family, whatever, you could make someone a statutory power of attorney. So on your behalf, they could do it for you while you're unavailable. Okay. All right. So an estate, what is an estate, right? Sometimes people think of an estate and you picture a castle, with a moat and a drawbridge. But an estate it's your house. It's, if you have any rental property, certainly. Sometimes people have a family cabin with a lot of memories and can have a lot of family emotions tied to it. Of course, retirement accounts, 401ks, any stocks, bonds, mutual funds, or cash that you might have. But in addition to those kind of obvious assets, it would just be stuff, right? Stuff there's no beneficiary designation. It's just, but there's some stuff that's valuable, right? For example, let's say you have 2 daughters and you have 1 wedding ring. Who gets the wedding ring? And you don't want them fighting over it, right? So it's better to just think through some of these things and have a plan for it. I know there was one lady said, "Oh, that's no problem. I have lots of wedding rings." So everyone's situation is unique. So typically when you pass, you want your assets to go to your kids if you have them, or whoever your beneficiaries are. It could be charities of your choice, whoever your heirs are. And typically, you'd like 100% of those assets to go to them. And you typically would like it to not have to wait years, right? Quickly and effectively. Now, there are some reasons why you may not want assets to go to a certain beneficiary quickly, right? If you, let's say, for example, you had a child with a drug addiction or some other thing going on in their life where getting a big chunk of cash is not necessarily good for them, and it's not what you want. So that's where a trust can really help manage that, and you can meter the assets. So over time, based on certain ages, based on certain conditions, however you wanted to do that, but a trust actually gives you can control assets from the grave based on conditions and based on, so it's not necessarily immediate. So I have, I call these unintended beneficiaries, okay? So there are some unintended beneficiaries that you want to be aware of that they're going to take a chunk of your estate, right? So first thing that comes to my mind is the IRS. The IRS is one of your beneficiaries, whether you know it or not, right? So that's where planning really comes into play to help preserve more of your assets. But also long-term care is a big one. So if you have, so statistically, 70% of us, let me say it this way, 30% of us have an independent life, and then the day comes and we pass away in our sleep or in a fairly short amount of time. That's about 30%, but 70% of us, we tend to die slowly. And so we end up needing some form of long-term care. And Jolene, you said you've seen it?
No, I said it's messy.
Yeah, it's messy.
Messy.
And you've probably maybe seen it with family or friends. And so long-term care becomes an expense that can really deplete assets. So Medicare doesn't cover any long-term care, right? Medicaid does, but Medicaid requires you, it would only kick in after you basically spend down all of your own assets. So if you have a husband and wife, and that one of the spouses is healthy, and the other one's, it could really change the long-term retirement of the other, because the sick one really depletes all the assets based on long-term care. So just, these are some unpleasant thoughts and an unpleasant subject. It's one of the reasons why estate planning is so procrastinated. Statistically, the majority of folks do not have any estate planning, the majority. And then those that do have it, a good percentage of them are kind of outdated with their planning and need to be updated. But it's easy for me to understand, right? Because who likes to really think about end of life stuff? It's not that fun, right? It's one of those things where it's like, yeah, I'll get to it. And it's just so easy to procrastinate. But the truth is, if you just kind of bite the bullet and you just get it done, you realize it actually isn't that painful. And then you have peace of mind going forward, right? So with Medicaid, they're going to, in order to qualify for Medicaid to help cover for long-term care expense, they're going to allow you to have one house. So if you happen to have more than one property, you would have to sell that property to pay long-term care expenses. You would not qualify. You can only have one car. If you're single, and this varies by state a little bit, but if you're single, you're not going to be able to have more than 2,400 in countable assets. And if you're married, that's like monthly. That's monthly, so income. And a married couple could have 4,000. That includes Social Security payments. So the community spouse is how you refer to the healthier spouse, or the one that's not still out in the community. They're not in a care center or whatever. They can have up to 162,000 approximately of assets, no more. If they have more than that, they just simply don't qualify. You don't qualify for Medicaid. You have to spend down your own assets, and then Medicaid kicks in. So how do we deal with that risk? Long-term care there's a couple different ways to handle it. There's what we call traditional long-term care insurance. It's not terribly desirable unless you maybe got it, years ago through an employer, and there's a few good plans I've seen out there, but really hard to get these days. And you basically, it's almost like having a whole second health insurance plan, because you pay a monthly premium for something that you hope you never have to use. And if you stop the payments, it goes away, just like health insurance would go away. So you're paying for something you hope you never have to use. And the premiums are not guarantees, they can go up. So a lot of people, when they look at it, they get to kind of retirement age, and they just think, yeah, it's not worth it. It's too much, too expensive. And so they'll just kind of roll the dice on it and say, well, hopefully we make this work. There are some newer types of long-term care policies. So there's some new solutions. We refer to them as a hybrid, and it's where they're asset-based. So you can put some money into a certain type of long-term care policy that will give you a nice multiple of a benefit, 2 or 3 times the value of what you put in for long-term care, and in a tax advantaged way. But then if you end up not needing it, or not using it, or not using all of it, then it just passes to your family 100% or more. And so either you or your family are going to get it. And so it's actually can be a really nice solution. And there's a few different ways to do it. There's, some of these life insurance companies who have got creative. So there's some life insurance strategies. They're specifically designed for long-term care. There's actually some annuities that, so there's also typically an underwriting requirement so that not everybody can get them because they want to make sure you're healthy, They manage the risks they take on. But there are some in the form of an annuity that'll give you the same tax advantage, a 3 multiple, and you don't have to qualify. And so everyone could do it if it made sense for them. And there's a few different ways to address that issue. Anyway, or if you don't have anything, then it's, you take the risk. In life, there's a lot of risks, right? Some risks we absorb and we just kind of assume the risk. Other risks we transfer to an insurance company, right? Like our house burning down is not a risk anyone is ever really comfortable with because that would be so devastating. So we have homeowners insurance, right? We have auto insurance. Anyway, so some things we insure, other things we don't. Long-term care is one that you may be interested in just considering what that looks like and looking at one of these types of policies. Anyway, so what does it cost in long-term care? It's not cheap. It's the rate of increasing for health care in general is super high, but for custodial care in a nursing home, it's right in the range. It depends on where you live, but it's right around 114,000 per year. So that can deplete a portfolio pretty significantly. If you're at home and you have nurses maybe coming to you, which is more ideal, right? Stay home as long as you can, 72,000. And of course, those numbers could fluctuate depending on what your situation might be like. All right, so let's talk a little bit about taxes and with estate planning. So depending on your nest egg and how things are going, if we look at the rule of 72, okay, the rule of 72 is just a simple way to say, well, how long will it take for our money to double? And if you have a 9% rate of return, for example, assuming that's what you get, in 8 years, your account would be double in size. So, of course, it depends on what your rate of return is, but if you have a 20 years or 30 years of a retirement time horizon, you could expect your portfolio to have doubled or tripled typically, right? As we do a lot of retirement planning, it's not uncommon for us to be, we're talking with a client and they're looking at their account balances, they're looking at their income, and they're thinking in terms of, okay, well, this is what we got, right? This is our nest egg. And what I often will say is most of the money you're going to spend in retirement, you don't even have it yet, right? Because of growth, Social Security you haven't got yet, if you have pensions. But if your money is growing, then over time you end up having more. So at end of life, sometimes people are surprised how much they've got. I mean, some people are worried about running out, right? Which is legitimate. But a lot of times, depending on your situation, it becomes so you might think of it from a tax standpoint. Well, let me give you an example here. Okay, I'm going to tell you a tax story. Okay. So in America, most of our retirement savings is done in these types of accounts, 401ks and IRAs, right? And whether you did a lot or you did a little, whatever it is, the more you have, the more of a tax issue you have, right? And so everyone was taught to do this, and that's what was kind of the default, but was to take the deferral. You defer the tax on your income. The money grows tax deferred. So you get to retirement and it's all tax deferred. It's all yet to be taxed, right? So you get to RMD age, so you reach an age where you have required minimum distributions. And that's going to be age 73 or 75 now, depending on your date of birth. If you're born after 1960, then it's 75. If you're born before 1960, it's the 73 group. But then whether you want to take money out of that account or not, you're forced to, right? And it's taxed as ordinary income. Okay, so we have a marginal tax system, right? And the more you have, the more income you have, the more tax you pay, right? That's how the system works. Now, is our income tax the only tax that our assets are subject to? No, there's also capital gains, right? Capital gains, that's going to be on non-qualified accounts. So that would be any investment account, brokerage account, real estate, any gains or profits, okay? So your capital gains has 3 brackets. It has a 0, it has 15% and a 20% bracket. And what determines what you're going to pay, it comes back to this. What your income is here is going to determine what you're going to pay over there as well. So we refer to these as a tax trigger. So you can have a certain amount of income and it ticks up additional other taxes that get kicked in. The determining factor is how much you've got. Okay, and there's more, right? How about Social Security? Now, Social Security has 3 brackets, 0, 50, and 85%. So that's up to 50% or 85% of your Social Security benefits taxed as ordinary income. Now, you all might be thinking about, wasn't there a new tax law just passed, the big beautiful bill? So you want to understand what that is. So I know it was Trump's harsh desire to eliminate taxes on Social Security. It didn't happen. The Senate threw that out. But what they did instead was they said, we're not going to do that, but how about if we just give the seniors an extra deduction, okay? So if you're 65 or older, there's an extra $6,000 each for the deduction. That will translate into most Americans. It's about 80% of Americans. It's going to effectively wipe out their taxes on Social Security. But here's the thing. It only lasts till 2029. It's not a permanent thing. So it's going to sunset. So it will require a future Congress, a future administration to make that permanent, which may or may not happen. And even with the deduction, not everybody gets it because there's an income threshold. So if you're single and you make more than 75,000, you're not going to get the full 6,000 deduction. You're going to start to be phased out. And then depending on how high that goes, then you can be completely phased out. For a married couple, it's at 150,000, and you'll start to get phased out. So it's not as awesome as it may have sounded, unfortunately. And then at 65, typically we're looking at Medicare, right? And how much does Medicare cost? And what determines your Medicare premiums? It comes back to you, to the income, right? So this will trigger additional taxes, especially if you've done no proactive tax planning. Now, so what happens when you die? Okay. So here are your beneficiaries. And when a beneficiary would inherit an IRA or a 401k, in the past, they could do what's called a stretch IRA, which means they could stretch it over their lifetime. They had RMDs. The person that inherits has RMDs, but they could stretch it over their lifetime, and they're typically younger, so it was much more tax efficient. It didn't force a big tax issue. But the Secure Act changed that in just a few years ago. And so now we have 10 years. So when someone inherits an IRA, they have 10 years to completely empty the whole account. And so this is a huge tax, I guess you could call it a tax increase, tax loss, whatever you want to call it. More money as money transfers, and how much money do we have right now, just in the United States, just with baby boomers? It's like $30 trillion in baby boomers accounts that will be transferring. And most of it, it's more than 30 trillion, but 30 trillion is in IRAs and 401ks. Yeah, and so when that passes to the beneficiaries, let's say, so we have a client, she has some rental properties, she has an IRA with $1 million in it. She also has, and she has plenty of income. She doesn't really need this $1 million IRA. And she says, Lane, that's just going to go to my son, right, when I die. She says, no, if I needed it in the meantime, of course it's there. And so she's of RMDA, so she's taking RMDs, and she doesn't really need the RMD money, so she just puts it into an investment account where she can be taxed on the capital gains, right? And so here's the scenario. So her son is a professional, so he's got a pretty good income. And so when he inherits it, where does that money go? He has to empty $1 million in a 10-year period, and it's on top of his income. So now right now, she's only in the 12% tax bracket based on the income that she's taking. But is he going to be paying, when he inherits it, is he going to be paying 12%? No. Not even close, right? So, I mean, this is just a rough estimate, but on $1 million, he could easily be getting about $600,000 after taxes, right? Pretty easily. And so now, since she's alive and well, we've got some opportunities here. So she could be strategic and actually do some Roth conversions, multi-year. You want to do it over time. You don't want to do it all at once. Pay tax at 12%, which is the lowest it's probably ever going to be. Get the money into the Roth, and now that the money's in the Roth, it's forever tax-free. It grows tax-free, no required distributions. And if you've got income coming out of a Roth, what do you think that does to your, the tax brackets? Nothing, right? There's nothing there. What does it do to increase your Medicare premium? Nothing. Does it cost more on Social Security? No. How about capital gains? No. So the Roth is really a very desirable account, but you got to get money into it, and you got to do it strategically over time, because you can do it too fast. There's nothing stopping you from just doing it like that, but then you're going to be paying way too much in tax, right? So you got to, we call it tax bracket management. It's doing it carefully year by year, making sure you don't trigger some of these other taxes in the process. But you can save a significant amount of money to yourself and to your beneficiaries with proactive tax planning. And that's a big part of what we do here in our firm. So now what happens at death and you've got a Roth that passes on? It's the absolute best way to pass on assets. So they are going to be getting a tax-free account. There's absolutely no tax implications to them at all. And they can keep it for 10 years and get tax-free growth. If they've got it invested well, it could be double whatever it is at death, and that's all tax-free growth, right? So what might be thought of as initially as maybe a modest gift becomes a greater gift just by having money in the Roth. So how much time have we spent here? We're right at about an hour. Wow, we timed that just right. So we have this process, just so you understand what it is. We call it the 5W Retirement Blueprint. As financial planners, we address all 5 of the key areas of retirement planning or financial management, wealth management, retirement income planning, certainly, investment strategies, tax planning, healthcare planning, and estate planning. And so I want to talk to you about what are some of your estate planning options, just so you can kind of know what your options are there. But this is kind of what our process looks like. We address all the issues. It's what we call holistic comprehensive planning. This is the office that you guys are sitting in, people online. This is our team, and we work in all 50 states. We have clients spread around the country. And so you're all eligible for a free review, a consultation if you would like. And I know we've got some of our clients here that we've already consulted with you, but we're glad you're here. So let's talk about if you don't have any estate planning done, what are your options? Okay. Option one, because we're not attorneys, right? Option one is you find a good estate planning attorney. If you're in Arizona, we know someone we can refer you to, but here's some things you want to look for in a good estate planning attorney. They're typically going to be probably $3,000 to $4,000 to get all of your estate planning documents in place. But what you want in an attorney, that if you're going to pay that price, is you want them to be like kind of like a lifetime guarantee where they can call you. There's no additional charges, or you can call them rather. You can review or make changes without any additional costs. At your death, they will help settle the estate, no additional cost. That's what a good estate planning attorney would offer. But we also have a $600 package where we help do it for you. So there's a team of attorneys who have put it all together. They drafted the documents, and they call it a complete estate planning package. And it's literally $600. What you do is it's a questionnaire, so you're not going to be necessarily face-to-face with the attorney. Rather, you're going to be face-to-face with us, me and my team. It's a questionnaire you go through. It's quite easy to make the decisions on each of the things. You get that back to us. We draft the documents. We help you notarize, witness, and even wherever you are in the country, we have several notaries on our staff, and we have a remote notary. Barbara on our team that's actually a thing. Remote notary is now a thing, and she's licensed to do that. So regardless of what state you might be in, we can notarize your documents for you and help you. And then the key thing is knowing how to fund the trust and how to actually use them once you have them. It's part of what we do. But in any case, we hope that you would, if you have any financial related subject you want to have us look at, review, you're invited. We don't charge you for it. We just like the opportunity to talk and meet. And then if it makes sense for us to do something, then we can talk about what that would look like. So any other questions before we break or before we end today?